Weddington, so far on the merits, you've told us about the important impact of this law, and it's made a very eloquent policy argument against it. I trust you are going to get to what provisions of the Constitution you rely on, because, of course, we'd like to sometimes, we cannot here be involved simply with matters of policy, as you know.
Your Honor, in the lower court, as I'm sure you're aware, the court held that the right to determine whether or not to continue a pregnancy rested upon the Ninth Amendment, which, of course, reserves those rights not specifically enumerated to the government, to the people. I think it is important to note in a law review article recently submitted to the court and distributed among counsel by Professor Cyril Means, Jr., entitled The Phoenix of Abortional Freedom, that at the time the Constitution was adopted, there was no common law prohibition against abortion, that they were available to the women of this country. Certainly, under the Griswold decision, it appears that the members of the court in that case were obviously divided as to the specific constitutional framework of the right which they held to exist in the Griswold decision. I'm a little reluctant to aspire to a wisdom that the court was not in agreement on. I do feel that that the Ninth Amendment is an appropriate place for the freedom to rest. I think the 14th Amendment is equally an appropriate place under the rights of persons to life, liberty, and the pursuit of happiness. I think, in as far as liberty is meaningful, that liberty to these women would mean liberty from being forced to continue the unwanted pregnancy.
You're relying in this branch of your argument simply on the Due Process Clause of the 14th Amendment?
We had originally brought the suit alleging both the Due Process Clause, the Equal Protection Clause, the Ninth Amendment, and a variety of others.
And anything else that might have been.
Yeah, right. Since the district court found the right to reside in the Ninth Amendment, we pointed our attention in the brief to that particular aspect of the Constitution. But I think we would not presume. I do feel that in so much as members of the court had said that the Ninth Amendment applies to rights reserved to the people and those which were most important, and certainly this is, that the Ninth Amendment is the appropriate place. Insofar as the court has said that life, liberty, and the pursuit of happiness involve the very most fundamental things of people, that this matter is one of those most fundamental matters. I think in as far as the court has said that there is a penumbra that exists to encompass the entire purpose of the Constitution, that I think one of the purposes of the Constitution was to guarantee to the individual the right to determine the course of their own lives, insofar as there was perhaps no compelling state interest, and we allege there is none in this case. That there again, the right fits within the framework of the previous decisions of this court.